Okay. Bismillah wa salatu wa salam ala rasulillah. Assalamu alaikum. Good evening and welcome to today's session. This session is being recorded and I wanted to thank everybody for their participation. This session is a very specific session as it is really there's no format other than a very open Q&A format for you to be able to ask any questions you have that, in my opinion, or in, I guess, the process of completing your Muslimwill's will, there's been something that's been a hiccup for you that's caused you to stop the process. So what we've identified is a list of people who've created accounts, who've started the Muslimwill's journey, but essentially haven't completed their Muslimwill's journey and haven't reached the finish line, which is finalizing their will and organizing for execution. Now, why that's so important, as you know, is because if you die without a properly executed will, then you're known as having died intestate meaning without a will, and all the provisions of the legislation apply to you, which means that your estate will not be distributed according to the Islamic criteria. Now, for today's session, I am not going to go through, unless somebody wants me to, I am not going to go through the A to Z of Islamic wills and inheritance. I'm not going to go through the intersection between Islamic law and succession law. And I'm not going to cover things like fara'id, inheritance calculator, things like that, because the point of this session was a Q&A format to help people finalize their will and ask questions. If you are interested in any of the topics that I just mentioned, we do have a plethora of recorded resources that you can send an email through and we can shoot and send back to you. I also do have some webinars on very specific topics. So for example, if you are a divorcee or a separated person, there's very specific legal issues that apply to you from a family law perspective as well as the estate perspective. There's a recording we can send you on that, and there's an information sheet that we've put together. If you are a widow or a widower, I do have a session coming up on the 30th of August that you can tune into, inshallah, which again would have specific issues and complexities around that topic. And if you're just, again, want a refresher on A to Z of Muslim wills, the intersection between succession law and Islamic wills, and any other topic in terms of the actual content, we do have that available and we can send that to you. But the purpose of today's session is really a very open-ended Q&A session to enable you to ask me your questions. So by way of housekeeping, given that it's a general Q&A session and I'm not here to lecture, I'm here to actually interactively answer your sessions. I'm happy for everybody to switch on your microphone, switch on your video, if you want to ask me a question directly. And if you want to ask me a question directly, the way you can do that is just put the little hand up arrow and I'll see against your icon that you want to ask a question. And I'll just say your name according to the name that you have. You can ask me the question and we can have a conversation about it. If you don't want to ask a question directly through video feed or audio feed, you're more than welcome to drop it into the chat link. And then my colleague Fazin will be collating the questions and sending them to me to read out. And if you really don't want to send anything today, then you've always got the Muslimwill's email that you can send queries to. You can also call us and we can have a further conversation. I guess the added bonus of this session is that I am a solicitor and I am able to give you some more specific guidance that I guess the customer service team might not be able to do that. So that's the benefit of being able to have this conversation with me during this session, inshallah. And that's why we're sort of keen to have this conversation started. So I've got my first lovely volunteer. I've got Ali who wants to ask a question. So Ali, feel free to turn on your mic or your video and you're welcome to ask a question.
Assalamu alaikum. Can you hear me?
Yes, wa alaikum assalam.
Okay, I have few questions which I was not sure. That's why I joined. So,
Yep.
do you want me to ask one by one, or should I just go through all together?
No, let's do one by one. That way we can
Okay.
sort of talk to the question and see what we get through, inshallah.
Okay, so my first question is the guardian. If so, all my kids are under 18. So,
Yes.
can the guardian be from overseas, or whether we should avoid it?
Yeah. Look, that's a very, very good question. And I would say from a very plain legal perspective, yes, your guardian can be from overseas. However, there's going to be significant logistical and operational issues if the guardian is overseas and the children reside in Australia. So what you would need to do is think about the following things. Number one, if you do pass away and your partner passes away concurrently, which means together, who is supposed to be the interim guardian for the children while the children actually make it to their guardian overseas, or whether the guardian comes here? So we strongly suggest you have sort of a person to act in the interim or in the meantime to make sure that while the guardian overseas comes to Australia or the children go to the guardian, there's someone caring for the children and their affairs in the event that you and you and the children's other biological parent pass away. That's number one. Number two is if you are separated from the your spouse or the biological child of the children, then, depending on whether or not there's any arrangements in relation to the care, development, and well-being of the children, or if there's any family law orders in place, you may be prohibited, for example, from relocating the children overseas. So that's something to bear in mind if you are a separated person. And number three is the financial cost of, for example, a relocation or say a guardian coming to Australia. So if that's something you're thinking about, I would be very I guess conscious of the fact that setting up some sort of financial provision for this guardian to be able to, for example, relocate, or for the children to relocate, that can mean a lot of money in certain circumstances. So considering, for example, how do we fund this process? And you can do two things. You can set up something during your lifetime. So, for example, a particular trust, or you can put some money aside in an account or gift money to a particular person and say this is for this purpose. Or if you leave it to after your death, Islamically, you're allowed to have up to a third of the discretionary component of your will, which is the wasiya section, targeted to this. So, for
Mm.
example, you can say, I want a particular portion of my wasiya to go to the caregiver of my children. Or, for example, I want 2% of my wasiya to go to relocation expenses for my children. So yes, it can be done, but there can be issues with that. I've actually just published an article on this on muslimwills.com.au. Fazeen will link that in the chat box. So if you want to read on this topic further, we've just published an article, inshallah, that will link below.
Sure, Jazakallah. Okay, my second question
Oh, sorry,
is,
sorry. I just remembered something else. Sorry, Ali, to cut you off. Um, I would be very clear about putting together in the Muslim Wills platform, after the guardianship section, there's a question that says, do you have any other instructions for your children's guardian?
yep,
I would
yep,
put together a very clear list of instructions. Okay.
okay,
So,
okay,
I want this to happen to my child. I want this person to come. You can put the airline you want your kids to go on, right? I want children
okay,
to be, going to this school, this university. People put, for example, I
okay.
want the children to be able to marry who they would like, whatever details you want to put them so that way people don't have to guess what you wanted. And as I said, if you and the children's other parent are together, make those decisions together so there's no confusion about what you want, what mum wants, and things like that.
But then, is it legally, guardian is legally bound to follow those instructions?
Look, good question again. So this is the intersection between succession law and family law. Okay. So what we're talking about is what happens is, for example, if the guardian doesn't follow your instructions, okay. Number one is it like, for example, a preference? So for example, I want my children to eat organic food, okay, and the guardian doesn't give them organic food. Realistically speaking, is this something that, in this life you can take up with them? And would anyone find out? And can anything be done about it? Probably not. Okay.
Yeah.
However, if you have concerns, or if any person has a concern about the care welfare of a development of a child, okay, they can make an application to the family court to be granted orders in relation to that child. And it's up to the family court to make a decision about what to do in this instance. Okay. So, for example, say in your guardianship nomination, you put the children's, let's just say your friend, okay? And
Yep.
your friend's not doing a very good job, okay?
Yeah.
And the children's auntie is actually very concerned about the children. The children's auntie, for example, can bring an application to the family court and say, look, I'm concerned about these children, 1, 2, 3, and make a case to the children's court about what's going on for the children. And it will just be assessed as any other case that's going to the family court. Okay. So it's
Okay.
very hard to say, what happens and whatnot, because from a legal
Mm.
standpoint, it has to be something that you can actually bring a case on. Um, the other thing is, if someone brings a case in the family court in relation to a child, any parenting orders made by the Family Court of Australia trump a direction that you've made in the will. However, it's really good to have directions made in your will in relation to your children, because the court will take that into account. Okay, so for example, say you made a direction that you want your children to be with your brother, the uncle. Okay,
Mm.
then
Mm.
upon death,
Mm.
there's a disagreement between, say, the uncle and the auntie, and they're fighting about,
Yeah.
who's going to take care of the children, right? Then, for
Yeah.
example, they might bring an application to the family court for that to be looked at. The court will consider your wishes in your will, and any logic that you put in. So, for example, I have this preference for this reason. Okay. So the
Mm.
more detail and the more information you can put in there, although it's not legally binding and enforceable if the matter ends up in court and there's a challenge to that, it can be taken into account by the court in those instances.
Sure. Okay.
Hmm.
Thank you. All right.
No worries.
My second question is, so for the if like I've put application for myself and for my wife both. Of course, she
Yep.
gonna fill her own will, but
Yep.
we don't agree on the guardianship person.
Yes.
She at the moment she don't have any clue who she, because
Mhm.
she wants to give guardianship to someone who is overseas, and I want to give guardianship to someone who is here. So
Yeah.
what
Look,
if
Ali,
now
I would tell you, yeah,
we
yeah.
put
Look,
different
I would
name?
tell you, you have the same problem as 90% of our users, because
Mm.
you're saying someone overseas, someone in Australia. 90% of our users, the woman usually wants someone from her family, the man wants someone from his
Yeah.
family.
Yes. Yes.
Yeah,
Yes.
yeah. So is your
So
question
what
what happens in that instance?
exactly? So if we both have different name, and we both die together, what will happen then?
Yeah. Look, that's a really good question and a very hard question, because essentially it's whatever ends up happening sort of organically as it happens, right? If there is a discrepancy between the wishes of two biological parents, there's no court order saying, this person has sole parental responsibility or giving them sole decision making, then really it just comes down to an operational issue. And what I would say is it's actually good that this conversation is being had while you're alive and not being
Mm.
had by people that are not the parents after you're dead. And they're making that hard question or hard decision,
Mm.
right? So imagine how hard it is for you and your wife right now to agree.
Mm.
Imagine
Yeah.
that strangers are making that decision for your children when you're not around. Okay.
Yeah.
So
Yeah.
unless it becomes a very serious matter which involves court intervention, it just really ends up being whatever the agreement is on the day, right? So for example, if your
Sure.
wife, said, there's somebody in Australia that can take care of them, that person is immediately available. They come, they start taking
Mm.
care of the children. The person overseas still hasn't found out. It takes a few weeks for them to find out. Then there's going to be
Yeah.
a discrepancy between those two people. They need to work it out and look at options like, for example,
Yeah.
mediation, getting family involved, discussing things. And if worse comes to us and they really can't agree, they may actually need to bring an application to the court to reach an agreement. Okay. So what I'm
Sure.
saying
Sure.
is have that difficult conversation now, even
Yeah.
not in your case, but for the other users listening. If you are separated from the children's biological parents, have that conversation now. If both of
Mm.
us pass away, who's going to take care of the children? And have a mutually agreed person, because in the absence of a mutually agreed person, you're leaving it up to a lot of problems later down the track.
Mm.
Ali, I'll let you continue in a second, but I'll just tell you I had a case. I have a separate family law practice and family law matters that I litigate. And there was a very, very unfortunate case in which the mother passed away, and the father and the mother's family were actually, going really well for a few years. There was a particular incident that led to disagreement. And the father
Mm.
said to the maternal family, no one's allowed to see their children anymore, categorically. Okay.
Mm.
Obviously, this is different because the father was still alive and he was able to exercise parental responsibility. But I'm talking
Yeah.
from an emotional perspective.
Yeah.
Imagine just, having the children have people that were in their life that they care about, that those people care about them deeply, just ripped away from them because there was no decision making, like a framework for that. Okay. So what I would say
Yeah.
is I would really be having a conversation with your wife, trying to agree on someone. And even
Sure.
if, for example, you appoint two people, so you say, look, I want you guys, work together because it's not easy raising children that are not your own. Please work together,
Yeah.
make it happen. But really, it's on you and your wife, inshallah, to reach an agreement and make it happen.
Sure. Jazakallah. Thank you. That was
No.
very detailed. Thank you. My another question is, so where can I, because I when I was trying to check the vault, it says that please don't put any passwords or any bank details in there, like passwords. So what do you
Yes.
suggest? What should we, how, let's suppose if I want to communicate all those details to my wife, not now,
Yes.
but when I die,
Yes.
then what's the
Yep.
best way to do it?
Very, very good question. So what I would suggest is you actually, how legally the will is actually the printed document that's signed. That's what the
Yep.
legal will is. Okay. So for example, when you pass away and you have assets and your family needs to make an application for probate with the court, they actually need to produce the hard copy document that has your wet signature on it. Okay.
Okay.
So usually what people would have that hard copy will, they would have title deeds to their house, they would have important documents. What I would do is actually print, for example, a list of passwords on a hard copy paper and keep it with important documents and tell my executor, when I die, this is where my will is. And it also has a list of my logins, for example. Okay.
Okay.
We don't recommend people keeping a list of the logins and their actual accounts on any online profile, because, for example, if hackers can hack, government and
Yeah.
Medicare, like
Yeah.
in a cyber world where hackers are just doing everything, you never ever want to have an account and passwords in the one place. So passwords,
Yeah.
my recommendation always is print it out, hard copy, and verbally tell your executor where that is, even if they don't have access to it. But just so when you pass away, they know where to get a copy from.
Sure. Okay. Another question is, when I was filling the whole thing, I did not see anywhere where I can put my kids' child details and how many kids I have and things like that.
Very,
So
very
is
good
that,
question.
yeah,
Yes. So on the will, you would have seen two things. Number one, it doesn't ask you for details of your family members. And number two,
yeah,
it also doesn't tell you Islamically, like who do you want to actually receive from your estate, other than for wasiyah section. Why did we do this? Okay. The reason being, from an Islamic perspective, inheritance law is always changing day by day. Okay. So, for example, you could have made a will, signed the will, next week you're separated or divorced, and that separation or divorce Islamically changes the inheritance entitlement. Okay. So
yeah,
immediately, due to the separation or divorce, that will becomes invalid from an Islamic perspective. Or, for example, you have a child, or mom passes away, dad passes away, child passes away, right? So from an
yeah,
Islamic perspective, anyone being born, anyone being passes away, any marriages and any divorces change the system of entitlement from an Islamic law perspective, okay? So what we
yeah,
have done is to make sure that your will is as valid always as possible, even if you forget to change it because there's been a change in your family circumstances. We've done it
mm,
so upon your death, your executor, your nominated executor, gets your documents together, looks at your family, gets an updated list of your family members, who's alive, who's not, gets an updated list of your assets and liabilities, and then based on your will distributes those. Okay. So your question is going to be, okay, but my will didn't contain a list of my family and it didn't contain assets or liabilities either. Where would the executor get
mm,
that from, right? So
yes,
your
yes,
executor will get that from what we have on the website called the secure vault. So the secure vault is like, imagine like your your vault that you keep cash in, like the secure vault.
yeah,
uh,
yeah,
that's a hard copy. This is soft. This is digital. And it's made so you're able to always update it very, very quickly without needing to sign things and go through a whole process. Okay. So what I recommend everybody does, everybody on this call, what I recommend you do is go into the secure vault and keep an updated list of family members, and especially if your family members reside overseas. So from an Islamic perspective, it doesn't matter where they live. Like this is an issue that comes up a lot. For example, my parents, my brother, they live overseas, so they're not going to be considered for the Islamic inheritance. That's not correct. as long as the person is alive, from an Islamic perspective, they're eligible to inherit. Okay. So keep a list of family members and their contact details. Keep a list of your assets and liabilities on the secure vault. So when you pass away, your executor is able to know, okay, this is who's alive, this is who's passed away, this is what's available to distribute, and they'll attend to their tasks as an executor.
Is it a good practice to even make a list of all the assets, at least just assets like super details? And
Yeah,
although there
yeah,
is a
that's what
super
I mean.
detail, but
Yeah,
my
yeah, yeah.
share details and things like that, I've
Yes,
got
a
this
hundred
many shares.
percent.
Okay.
100%. That's what I meant. So on the secure vault, you should have a list of your assets and liabilities. Okay. So your
But yeah,
assets, everything like jewelry, superannuation, cash, if you have, like hard copy of, documents and things like that, you need
yeah.
to actually list everything, because if you don't, it's going to be very, very hard for the executor once you've passed away to actually find out where your stuff is. Okay. So keep a list of
So,
assets, and liabilities are anything you owe. Okay. So for example, your mortgage documents, if you've given anyone a loan, if anyone's given you a loan, any credit cards, personal debt, anything like that, keep a list of those.
mm,
And the most important one also is Islamic liabilities or debts. Okay.
yeah.
Who, like, really, if any of us died right now, would your partner know if you have unpaid zakat? Probably
Mm,
not, unless
yeah.
you've had a conversation about it, right? Unpaid
Yeah.
kafara. For the males on this call, dowry Islamically is a debt on your estate if it's not paid during your lifetime. So you actually
Mm,
should note how much the dowry is that you haven't paid, if you have an amount that's unpaid, because that actually needs to be paid out of your estate if you die before anything else is distributed. Okay? So all those
yeah.
details, your Islamic obligations, what you still owe, need to be on the secure vault. So if I am your executor, you pass away, I come and I have a look at all the assets. This is everything this person has. This is all the liabilities. I deal with the liabilities, I pay them out, then we are left with the assets, and that's what gets distributed. Okay. All of this doesn't get included in your will. This is all the secure vault. So you need to still attend to those procedures on the secure vault to make sure that your estate planning, as a plan, everything is ready. The will is one piece of the puzzle in an estate plan.
Sure. Okay. All right. My last question is
Yep.
with this secure vault. So let's suppose, of course, I was unable to pass the passwords and all those details to my executor.
Yes.
And even like, to be honest, my wife doesn't know anything because I know her all her passwords. She doesn't care about my passwords.
Yep.
So what if I die without telling her all the details, but now she knows the number of assets I have, like what bank accounts I have. It's everything mentioned in the vault. But can she now take this will to the bank and tell them that, okay, he was my husband and I need to like get all the details? Although I have
Yeah.
put her name in the like next to kin, but what if we both dies together? So can my executor can go and access that money legally?
Yeah, so if it depends how much the money is, right? So if the money, different banks and different credit unions have different limits. If it's under a certain amount, what they do is, if you just have a death certificate, you can prove you're the next of kin, or you're an authorized signatory on the account. They will release those
Yeah.
funds to you if you meet that criteria. Okay. If we're
Okay.
talking about significant savings and investments and things like that, the bank
Yeah.
may not agree to release it without what we call a court process, so either a grant of probate or letters of administration. Okay, so a grant of probate is the legal application that an executor makes to the court when somebody passes away, that allows them to distribute the estate according to the laws and also according to the will. If somebody dies without a will, the same process is called letters of administration, and a person or an administrator is appointed by the court to deal with the assets after the person passes away. Okay. So what your
Sure.
wife would do in that instance, again, it depends how much the money is we're talking and which institution holds it. But the
Yeah.
death certificate confirmation of ID goes to the bank and is able to retrieve that amount.
Awesome. Thank you very much. That's all from
No
my side.
worries. Jazakallah khair. Thank you so much, Ali.
Mhm. All right.
All right. I've got Gadao, Gadao, had their hand up.
Assalamu alaikum. It's actually my first name, Gada, and O
Oh,
is the
alaikum salam. I was like, oh, it sounds Interesting. Couldn't pronounce that one. How can I help
Uh,
you?
so I wanted to confirm, and when I went to do the will, in the wasiya section, it says you can't leave part of that wasiya to a direct beneficiary. But then there was another seminar that you did recently, that like another webinar, where you said I could leave it to a beneficiary as long as all the beneficiaries were aware that I wanted to leave an additional component.
That's correct.
Yeah, so I guess I wanted to confirm I'm divorced, but I've got, a son and a daughter, and I
Yes,
wanted to leave in the wasiya section for my
an
daughter
additional amount. Yeah.
an additional amount.
Yeah. Look, this son-daughter issue is very, very, very common. And I'm glad you've raised this because it allows me to talk on this topic, and I'm sure others on this call will benefit. Number one is the general premise Islamically is you can supplement a compulsory beneficiary with the agreement of all the other compulsory beneficiaries at death. Okay. So in your instance, for example, your parents are not alive.
No, unfortunately, my mum just passed a month ago.
I'm
Um,
sorry to hear
so
that. Allah
so
yarhamha.
yeah, so it's just my son and my daughter.
Yep.
My parents aren't alive, and then
Yep.
I have half siblings from my mum's side. So I've got a brother and a sister from my mum, but not the same dad.
Yep.
Um, but
Yeah.
yeah,
That
so
doesn't matter because so the way Islamic inheritance works, actually I've just got a slide on this, which I might just share real quick, just so everybody is also benefiting. All right. So this is really, really important to the sister's question. Fara'id, or the Islamic inheritance, who are the eligible heirs? Okay. So number one, we have the primary heirs. So that's a spouse, children, mum and dad. Okay. If any of these people are alive, they inherit full stop. That's it. Okay.
yeah,
So for example, if I just have a spouse and I don't have children and my parents pass away, then just my spouse inherits. In your particular case, sister, if you pass away, you haven't remarried before death, and your parents have already passed away, then only your children inherit. Okay.
right,
If, for example, you pass away, you haven't remarried, la samahallah, say your children have also passed away, your parents have passed away. In that instance, we don't have anyone who's a primary heir. Okay. So that's when we would go to secondary heirs. And that includes grandparents, it includes half brothers, half sisters, and grandchildren through the son. Okay. Then, if there's none of those secondary heirs available, that's when we go to distant kin, which is pretty much let's try to find someone who's eligible to inherit. Okay, so that's just something to just really, really think about. So it's not, for example, the Islamic inheritance is literally, sorry, let me just show you. The Islamic inheritance is these people. If they're not alive, it's these people. If they're not alive, it's these people. With the exception of these people. Okay. So I'll talk to this slide in a second in terms of who doesn't inherit. But in your particular instance, um, your son and daughter will inherit. Your son will inherit more than your daughter, and you want to supplement her. Okay. That's a really good question, and it comes up a lot. How do we do that? You can do it in one of two ways. Number one, Islamically, you can do whatever you want with your wealth during your lifetime. Okay?
yes,
There's no restrictions on that. So for example, if you wanted to transfer a whole asset to your daughter and not give your son anything, that's potentially okay from an Islamic perspective, although you should do justice between the children, and that's a hadith, right? If you wanted to, for example, set up a trust for your daughter that she's able to access with certain conditions, you can do that. So during your lifetime, there's nothing that stipulates you can and can't do this. And also during your lifetime, you're not at the mercy of anyone agreeing or disagreeing with a particular decision you've made financially. Okay.
yeah,
Islamically, however, the moment you pass away, estate planning takes you out of the realm of discretionariness and puts you into the realm of Allah subhanahu wa ta'ala has given us certain guidelines we need to abide by. One of those guidelines is the inheritance distributions. Now, when it comes to wasiyah, you can give an additional amount to your daughter within the 1/3 restriction, as long as your son agrees to that distribution at the time of death. Okay, so it's at the time of death, which is another issue because, for example, someone might just agree during your lifetime and say, yeah, when you pass away, I'll do it. But they will be asked again at the time of death. And it has to be with their consent for somebody who's already inheriting something to receive an additional benefit. Okay, so to answer your question, Islamically, is it okay to supplement an existing compulsory heir? Yes, as long as it's with the agreement of all surviving compulsory heirs, number one. And number two is they do have that veto power. So just sort of risk manage your decision accordingly.
Okay, so the second question then is that in my lifetime, if
Yep.
I've got, say, investments, I can then put them in joint names with my daughter, and
Yep.
then that is give it like, so then we're joint owners of that. Then, that'll show when I pass, if I pass before
It
her,
goes to
then
her directly.
goes,
Yes.
goes directly to her.
Yes.
So, okay. And
Yeah.
so you also talked about grandchildren from my son, from the son. Do the
Yes.
grandchildren from the daughter, they're not in the secondary? Is that what
No.
you're saying?
So that's right.
Because I
So
can't see that screen very well. Yeah, the
okay,
slide.
what I'll do, inshallah, is I'll organize for this to be sent out.
Okay.
But so grandchildren from your son, so son's children, if your son is not alive, okay,
Yeah.
they will inherit. But daughter's children don't inherit unless no one else is alive and they're part of the distant kin. Like there's literally no one alive from anyone who's eligible to inherit except them, okay? So if you do want to provide for your grandchildren, and this is something that's really, really important to know, and any of you who are on this call that are grandparents, provide for your grandchildren in your wasiya section. And it's actually really, really easy to do that, for example, by giving a particular percentage. So for example, because you might not know how many grandchildren will be alive by the time you've passed away, and you don't want to keep updating your will whenever somebody gives birth. Like, mashallah, sometimes, 3, 4 grandkids can be born in 1 year. You're not going to keep doing it, right? So what you can do is you can, for example, give a percentage of your wasiya. So for example, I want 5% of my wasiya to be equally distributed to my grandchildren that are alive at the time of my death. Islamically, that's completely valid. It won't distinguish between female and male grandchildren, and it won't distinguish whether they're female or male from, grandchildren from your daughter or your son. Okay. We do have an article also on that, and I'll get Fazeen to link it in the comments in terms of how do you word that distribution through your wasiya section for your grandchildren. But I would, if you want to think about leaving something for your grandchildren, chances are in most cases your children will be alive, so your grandchildren won't inherit from you. So if you want to leave something to the grandchildren, do it through your wasiya section.
Okay, yeah, because I think it's just because I came across that section where it said, I mean, my children aren't married, they're only 18 and 22. So it's more about, it said then that
In the
if
future. Yeah.
if the three of us die,
Yep.
who do I leave it to? So I just wrote to my grandchildren equally, even though I don't have any, because
Yeah, that's
it's that.
fine.
Oh,
Yep.
okay. And then if my siblings aren't Muslim, can they
Yes.
inherit from me?
No. So that's a really good point. So back to this slide, who does not inherit? Okay. So number one, grandchildren, if the son is alive, and as I said, grandchildren from the daughter generally, that's number one. Number two, stepchildren. Number three, foster children. Number four, adopted children. And number five, other family members if their preceding in the lineage is alive. But lastly, non-Muslim. So being non-Muslim is the only thing that takes you out of eligibility for inheritance, full stop, Islamically. Okay. So for example, you could be a very bad Muslim. You could be a non-practicing Muslim. You could be a Muslim that hasn't contacted the testator or the person passing away for 30 years. You're estranged from them. Okay. From an Islamic perspective, you're still allowed to inherit. The moment you leave Islam, and by leave Islam, I mean like it's very, very clear you're not Muslim. You've said you're not Muslim. There's witnesses to those statements being made. Then you're not eligible to inherit from the two-thirds that are called mirath or fara'id. Okay. So, for example, if say your sister's not Muslim and you want to provide for your sister, you will have to do so through the wasiya or the discretionary amount up to 1/3 because she won't inherit through the 2/3 of the mirath.
Right. So in that case, then, if my my children and I are involved in an accident and they don't have children, what then happens? Because
Well,
I
remember,
don't have, my parents have passed away.
paternal
My
uncles, paternal cousins,
my situation
great-grandparents.
is really difficult because I don't know. I don't know my siblings from my dad's side. I don't know who they are. They're from and so from my maternal side, unfortunately, they both don't, identify as Muslim. So
So in that
yeah,
look, sister, what I would do, just so for and this is really important for everybody on the call also, the distribution of your estate Islamically is your last act of ibadah or act of worship, like when you depart. So you need to make sure from an Islamic perspective, you've done everything within your power that you could to make sure that it's distributed properly. Okay. So in your particular instance, what I would do is while you're alive, I would actually be making inquiries to find out if, where possible, even for example, if you write to them and they never write back to you, who are your, for example, paternal uncles or paternal family members that are alive? Even if, for example, like these days, everybody's online on social media, Facebook, whatever, keep a list of them in the secure vault. Okay. Keep a list of them in your secure vault. That way, upon your death, your executor can contact them and say, look, this person, the testator, passed away. You're eligible to inherit as under, distant kinship category from the paternal side. And they might be interested, they might be not. From an Islamic perspective, you've done your bit, okay? However, if, for example, by the time you pass away, say your children are also not alive, and those people are not alive or they can't be contacted, like there's just no way of contacting them, then your estate falls into what we call a contingent estate distribution, okay? So that's one of the questions that we actually ended up adding to Muslim wills in the version 2, which is what you're all using. Because subhanAllah, there's been so many of these cases where people pass away and they actually have nobody. Previously, that used to be very rare because people had bigger families and they had so many cousins that there was always someone eligible to inherit. Right now, we are seeing more and more cases where there's actually nobody eligible to inherit. So what we have in the will is a contingent estate distribution. So contingent estate distribution means if nobody that's legally, from an Islamic perspective, eligible to inherit from you is alive at the time of your death, where should your estate go? Now, it's up to you where that goes, and there's no restrictions on it Islamically. So it doesn't have to go to a Muslim. It doesn't have to go to family members. Well, it can't go to family members, because they won't be alive. What we always recommend is consider putting a charity or an institution in that contingent estate distribution because charities usually outlive people. And have a charity and also have a backup. Okay. For example, a charity you can consider is Awqaf Australia. And you can ensure that, for example, the wording we've put on there is Awqaf or its successors. Okay. So that way, you make sure, because what happens is if you don't have anything in your will to cover it, there's nobody eligible to inherit. There can be instances where the government can actually claim those amounts from your estate. Okay. So if you can choose between it going to charity or the government, it's up to you which one you choose. But what I would be doing is putting in the contingent estate distribution, whatever the charity, and put in your charitable causes that you care about. Put in orphans, put in domestic violence, put whatever you care about. That way your legacy continues after you pass away also.
Okay. Inshallah. Thank you so much.
No worries, Jazakallah khair. Thank you, sister. All right, next up we had M. Feki. Sorry for me
Yes,
butchering names because I'm
that's it.
actually
No,
typing the title.
yeah, I do understand. Thanks a lot. I have a couple of questions I'm hoping that all attendees can benefit from.
Yep.
So the first one is I've started my will and it's in draft status now. I didn't finish it. So I
Yes.
was wondering once I finish it and click submitted, I can print it out and it's gonna be like a hard copy that I can send it to the executors. My question is, will Muslimwill be interfering in this will in terms of trying to send it to the executors whom I nominated during drafting the will, or the role of Muslimwill will stop at that time and nothing will be done from your side?
Yes, very good question. So number one is you can't just send it to the executor. So for your will to be legally binding and enforceable, after we send it back to you and we say this will it comes back as ready for signing, so it's been approved, it's ready for signing, you need to print it out and you need to sit down with two people that are witnesses, physical witnesses to you signing it. And those two people can't be the executor, it can't be the spouse of the executor, and it can't be anyone who's eligible to inherit from you under the will. So from an Islamic perspective, it really can't be any of your family members because you don't know who may be eligible to inherit from you. Okay. So because I'm mentioning this because you said I'll send it to the executor. You can't just send it to the executor. You need to physically sit down with two people. They need to see you sign and you need to see them sign concurrently at the same time. Three people together, wet signatures. It can't be electronic signature. It can't be emailed. Okay. Once you've done that, you've got a legally valid will, and the legally valid will is actually the hard copy. That's what the legally valid will is, okay? And you need to make sure you keep that safe because, as I said, if it needs to be used for legal purposes, we need the hard copy. Now, to answer your question, where does Muslimwill's involvement start and end? Muslimwill's involvement does not extend beyond two things. Number one is it gives you the document that's ready for signing. So it sends it to you and says, look, this is ready for signing. It's up to you to organize the signing and do what you need to do. And number two is there is a question that says, do you want your executors notified that they've been nominated under this will? If you say yes, all they do is they just receive an email saying, you've been nominated as an executor on Tasnim's will. Contact them. That's it. We don't go and give them a copy of your will. We don't tell them what you're up to. We don't do anything else. We have very, very strict privacy and confidentiality arrangements, and we don't do anything on your behalf. So even with the will, if you choose to finish it, print it out, and never sign it, that's on you. It's very, very important that you take agency and you continue the process. Muslimwills doesn't do anything for you or on your behalf.
Okay, perfect. Thank you so much. What if I wanted to update it later on? Should I restart the process, start over again, or how do I update it?
Very good question. So within your Muslimwill subscription, you're allowed unlimited updates free of charge for the first year. Okay. So the way you update is you just go back onto your dashboard, and there's a button that says update will. If you just click update will, it'll take you back to the will form with all the saved data. So it doesn't ask you to re-enter the data. The data is already saved. You just go specifically to the question you want to update. You change the answer and you click submit. When you click submit, we'll send it back for legal review. Legal review will approve it and it will come back to you. So you just update and submit. That's all you need to do, and it'll do the process for you, but you don't need to start from scratch.
Okay, perfect. Thank you. My last question about the instructions section.
Yes.
I heard you saying before that, yes, you can do whatever you want to add as long as it's realistic and can be performed under the instruction section. So under the instruction section, if I want to add things like the share that should go to the executor, like a sum that should be paid to the executor in order to be able to execute my will, and things like I want my car to be gifted to someone. Is it okay to put all these details under this section, and something related to this as well? If there is a conflict between what I have mentioned under the instructions section and the remaining clauses of the will, which one will take precedence over the other?
Very good question. So the way we've designed it is each section allows you to give instructions specifically to that section. Okay. So in the wasiya section, it says, do you have instructions about wasiya? In the joint asset section, it says, do you have instructions about joint property? End of life, about that. So it depends which part you're talking about. So for example, if you in wasiya, for example, you said, I want my nephew to receive 2% of my estate, for example, because your nephew wouldn't otherwise inherit from you, right? If, for example, the father is alive. So what you would do is in the instructions say the amount left for my nephew, the percentage left for my nephew, I want that to be in the form of red Honda car, for example. So then, where possible, it's the executor's job to make sure that they carry out your wishes where possible. But for example, if by the time you die, that red car is not available anymore, they will just attend to making sure that the nephew gets 2%, whatever the 2% equivalent is. Okay. So it's really just about practically, is your wish able to be executed at the time of your death? And for example, when it comes to asset, is the asset available? Does that answer your question, or do you have a more specific question?
Yeah, it answers, because actually this section was at the end of the will, where I need more instructions that were not reflected during the stages of the will. Because yes, during the stages of the will, I can add more instructions or some very specific instructions. But at the
Yes.
end of the will, before maybe the very last
Yeah,
stage
end
of
of
the
life
will,
wishes. Yes, and estate wishes.
yes,
Yes.
end of life wish,
Yep.
where I would say, okay, I need my ghusl, my janaza, my
Yes. Yes.
that nobody cry, things like that. This is
Yes.
where I wanted to add these particular
Yes.
sections of, like, I want to give the executors this sum of money to execute it. This is where I leave the will for my executor and take care of it and take care of my children, things like that.
Yes, yeah. Look, the children, I would put that in the guardian section. So that way whoever's appointed as the guardian knows exactly what you want to do with the children. If you want to leave a particular sum of money for the executor, I recommend that you so there's different ways of going about it. You can put it in end of life, or for example, if you know your estate is generally whatever it is, I can allocate a particular percentage to the executor in wasiya, because Islamically we just need to make sure that whatever you leave behind doesn't exceed 1/3. Okay, so when I review the wills, there's a problem. For example, if you've already allocated your wasiya at 33.3%, okay, then at end of life wishes section you tell me I want to leave my executor $10,000. I'm going to send that back to you for review. Why? Because the way it reads to me is both of those taken together will be more than 1/3. And Islamically, our product is an Islamically compliant product, so we don't allow you to make a direction about more than 1/3. Does that make sense? So what
Yeah,
I
it
would
makes
recommend you
sense. Yes.
do, what I recommend you do is we have an article that Fazin will link in the box below that tells you if you want to leave a specific sum to somebody, how do you convert that sum to a percentage? Because the thing is with percentages will always be carried out and it will never be above the Islamic allowed amount, okay? But when you leave money in the sum, like an actual dollar figure, depending on how much your money grows or loses, that value fluctuates. So that's why a
Yeah.
percentage is safe, money amount is not safe, okay? So there is an article that we'll link below that allows you to convert a sum of money into a percentage, so you can put that into the wasiya section without having problems Islamically. Okay, so in your particular instance, what I strongly suggest you do is put a percentage to the executor in wasiya, and in the description say this is to the executor for carrying out the duties of executor. Okay, the other thing you need to be aware of is that any executor, in the performance of the executor duties legally, if they need to, may also use, for example, a solicitor or accountant in undertaking the estate planning needs upon your death. Okay, so for example, if they need to make an application to the court, if they need to find money, if they need to do whatever duties they have, usually they may also hire a professional to do that. And any duties relating to the estate distribution that the executor undertakes, that money actually comes out from your estate. So before it gets distributed, whatever needs to be done to the estate, that money actually comes out of the estate.
Yeah, perfect. Thank you so much. I know that I said I had that was the last question, but very important question that came into my mind.
That's okay. Yeah.
I have nominated my wife as the executor for the will. But
Yes.
if in case of the unfortunate death of both of us at the same time, I have
Yes.
nominated my brother who is overseas to execute the will. So my question is there is a way that I can make this will legally binding overseas, like to go to the MC here in Sydney and get it testified and certified and
Validated.
then
Yeah.
validated,
Yeah.
things like that?
Yeah, look, very, very good question. I can't answer that because it depends on which country you're seeking validation in. So, for example, I can tell you the tool was designed to cater to Commonwealth countries. So, Commonwealth countries, for example, UK, Singapore, South Africa, we're all Commonwealth countries. So, the chances of another Commonwealth country accepting the will as valid are higher than if, for example, you had this will and you wanted to implement it in Jordan. Okay. I don't know because it just depends on the laws of that particular country. But what I would recommend is, as you said, call the embassy or the consulate in Australia and say, I have a legally valid will in Australia that I've made. How do I register that, for example, overseas to make sure that if I have any assets overseas, it also takes care of that. Okay. But if you don't have assets overseas and all you want to do is appoint someone overseas as the executor, you don't need to have the will registered in the overseas country. It's enough for them to have it valid in Australia for them to do the work in Australia, if that makes sense.
Yeah, yeah, it makes perfect sense.
Like you
Thank
only
you so
need to
much.
have it registered overseas if there's actually assets in that country.
Yeah, okay,
Yeah,
perfect sense. Thank you
no
so
worries.
much.
Jazakallah khair, no worries.
Jazakallah.
Thank you. No worries. Thank you so much, everyone. I can see all the questions coming through. What I might do is there's two more live questions. So I've got Hassan and Iman. I'll take Hassan first and then Iman, and then I'll get through all the questions coming into the chat box, inshallah. So stay online, inshallah. I will get to the questions. Hassan?
Assalamu alaikum. Am I
Wa alaikum
audible?
assalam. Yes.
Okay. So, first of all, the question is like in terms of this will, uh, would it be automatically distributed as per Islamic laws to my like predecessors, like my children and my wife, automatically, or do I need to mention the percentages?
No, you don't need to mention it. It's so when you finish the will and you send it for review and it's approved and it comes back to you, you
Yep.
will get a very lengthy document. The
Hmm.
first 20 pages or so are the will, and the last 30 pages or so are called an annexure of Islamic distribution guidelines. So
Hmm.
that annexure that we've put together with a professor of Islamic law, Professor Munir from South Africa, is the A to Z of Islamic inheritance law. Okay.
Hmm.
What it says is exactly who is to get what depending on who's alive. So what I was
Hmm.
mentioning to Sister Gada earlier, that if your parents are alive, the parents, children, spouse inherit. If they're not alive, it goes to this person. All that is already mentioned in the annexure. So when you're going through the will, you don't need to mention I want the will to be Islamically binding or for people to get the Islamic shares, because that's the
Hmm.
whole point of you using our product versus any other product, is that we've actually designed it for Islamic compliance.
Okay, all right. Okay, yep, thanks. And one more question that is slightly different, and I'm trying to connect the points. So
Yep.
I was also thinking, like, for example, let's say I was making a will, and I like say in the will that as my children are small, so can I give everything to my wife, and she then decides how to distribute the wealth amongst the children when they grow up?
Mm. No, because Islamically they're still allowed to inherit in their own regard.
Hmm.
However, there are provisions in the will, and we've already put this in, that if somebody is under the age of 18, that their
Hmm.
share is to be held in trust and also like managed for them by their guardian. So you don't need to put that specifically because, for example, if you do pass away and your children are under the age of 18 and your wife is the guardian and she's the only one alive, legally that will happen anyway. So you don't need her to give her additional powers to do that.
Hmm. Another thing is slightly different. For example, if they are at the age of 18 or like cross the age of 18, then I was thinking
Yep.
like my wife would be a bit old, and if she doesn't get enough share, maybe I'm not sure if she will be able to manage herself or not. In that case,
Yes.
would there be any possibility I can allocate her more or something like some money or something like that? Because I checked with the banks, they are not allowing me to add her name as a joint account holder.
Mm-hmm.
So in that case, how can I manage that one?
Sorry, I'm just a bit confused. So you're worried about if your wife is elderly
Yep.
and you pass away.
Mm-hmm. Yep.
So you're
And my
worried about,
children are 18, more than 18. So if
okay.
like, for example, if have I have I left with like very small amount of money, and if there is something like I can allocate her more so that she can manage herself, because my son would
Ah, yes,
definitely,
yes,
my
yes.
son's, yeah.
Yeah, that makes sense. Do you look, the what I would be doing is two things. Number one is if you have a property, okay,
Hmm.
and your wife is not on title for the property and you don't want to
Yep.
change the title to the property, what you can do is give your life what we call a life tenancy in the house, okay? So a
Hmm.
life tenancy is allows her to continue living there until she passes away without changing the share Islamically of who's eligible to inherit and without changing her living situation, right? So that's
Hmm.
something called a life tenancy, and you can set that up while you're alive. So that way, for example, your wife continues to live in the house without having an adjustment of any shares. It's just the right to live in the house. It's
Yep.
a tenancy. It's not a transfer or ownership. That's number one. Number two is Islamically, you are allowed to allocate her an additional amount up to 33.3% through the wasiyah with the agreement of the other beneficiaries. So, for example, if you have children and the wife, as long as the children agree, then the wife can get an extra 33.3%. Okay. And in those
Hmm.
cases, generally, especially if you've been the breadwinner in the relationship during the relationship, the spouse that's not the breadwinner that hasn't worked actually suffers a lot when their partner passes away. Okay.
Yep.
So Islamically, there are ways to provide for them.
Okay. And you said like I can allocate her like whatever the wealth is, 33.33% of that one as like as per Wasiya.
Yeah,
Up to.
yeah, not just the wealth of your whole estate, up to 33%, you can have that go to your wife.
Okay, all right, okay, all right. That,
Okay?
and this would be in addition to the like natural distribution of the
Yes,
shares. Yeah.
yes, yes,
Okay, all
yes.
right, okay.
So for example, I'll tell you, oh, sorry, I'm just trying to think. If you have children alive, okay, and you have sorry, it's just missed my mind. If you have children alive and your spouse is alive,
Yep,
depending on if there's boys, girls, if you have a parent, her distribution can be different, right? But generally, say if she gets 1/8, okay? If
yep.
she gets 1/8, she keeps the 1/8 plus 33.3% if that's what you've allocated her in the wasiya section.
Okay, all right, okay, yep. All right, okay,
Okay?
that's
Jazakallah
great.
khair.
Yeah, that was the main thing I was bothering, and I was editing and updating my will again
Yeah.
and again. Yeah,
Yeah.
yeah.
And as I said, look, if you want something other than money, so for example, if you have a house, also consider the life tenancy. And just for anyone interested, this life tenancy arrangement, which you allow the spouse to continue living, this was a suggestion by Professor Munir Abdul Rauf from Islamic perspective, and he said that that's something that they usually do that allows the person to continue living, but it doesn't change the Islamic entitlement. So there shouldn't be a problem with it legally.
Okay, okay, all right, okay.
Okay, Jazakallah
All
khair.
right,
Thank you so much,
thanks.
Hassan.
Thanks.
Thank you, Jazakallah khair. All right, I'll go to Iman and then I'll start answering some of the questions in the chat box, inshallah. Iman?
Assalamu alaikum.
Wa alaikum assalam.
I've got two questions, or maybe
Mhm.
three.
Yeah.
If one is divorced only Islamically and it's been a couple of years and you're not on speaking terms with the ex-partner,
Yes.
do they have any access to the inheritance if you're still married by law? So you haven't divorced yet by law. They still have access to your inheritance. Okay, so that needs to
Okay.
be.
Amen. This is a really, really good question. And everybody listening that's separated, thinking of separating or divorced, it's very, very, very important that you listen to the webinar that I did for separating couples. It's recorded, and there was also a resource sheet to go with it. If you're Islamically separated and that hasn't been legally documented anywhere, or even if you're not Islamic separated, there's a lot of arrangements where, for example, people continue living under the same roof for years and years on end. They don't share a bedroom. They don't really have a relationship with each other, but no one outside the house knows what's going on. Okay. And they might consciously do that so people don't know, or sometimes it's just subconscious, it just happens. If you pass away, it creates a nightmare from a legal and Islamic perspective. Number one is if nobody knew about it, especially Islamically, that person may still be entitled to inherit from you from an Islamic perspective. So your executor might actually not know that you were separated from them, and they might have eligibility to inherit. And if you pass away without a will and you die intestate, then a spouse under Australian law gets the entirety of the estate.
Okay.
A spouse under Australian law gets the entirety of the estate. So if you're separated from someone, it's not documented, nobody knows about it, and you pass away, it's a nightmare. That's number one. Number two, if you haven't finalized the documentation, that person can still act as your next of kin. So they will have access to your body, they will have access to your records, they will have access to decisions about, for example, like switching off life support, really, really serious decisions, meddling in your affairs. They could probably still be on authorized signatory or next of kin on your bank records. Okay, so if as I said, if you're separated, thinking of separating, or you've been divorced, please read. I don't have time during this call to go through the intricacies of it. Please listen to the webinar, read the information sheet. Also, if you've been divorced by an Australian court, a legally valid divorce order, so it's been issued by the court, you've waited the 1 month after it was issued, revokes a will. So if you had a will, a legally valid will done, you got divorced, that legally valid will has been revoked by the divorce order. Okay, so it's very, very important that you go back and you redo your will, because even if you had it ages ago and then you got divorced, it's not valid anymore.
Okay, because I had it on draft. I can't remember which question it was on. It was a couple of months ago, and that's where I got stuck. So that's why I just procrastinated. But
yeah, look, it's not easy, and I think sometimes it makes you face some decisions that you've otherwise put on the back burner. So it's completely understandable. But the good thing is it saves your progress wherever you were at. It doesn't refresh it. So if you need to continue where you left off, it's quite easy to do that. But please, if this is a situation that applies to you, read the brochure that I've put together. And also that there was a particular recording we did on separating partners. It's highly pertinent. Oh, sorry. The other thing is make sure you update your superannuation. A lot of people have their spouse as their super beneficiary, the nominated beneficiary. You need to update that, because again, if you haven't updated that nomination and you pass away, they get everything. On the Muslimwill's website, when you go through the question, the recommendation is for your super to actually come into your estate and be distributed according to your will. So either way, whether you're separated or not, everybody on this call, please remember, it's not enough for you to say, I want my super included in my will through the will. You actually need to contact your super, get your super provider, get a hard copy form from them. It's the only form that they need a wet signature on. You actually need to sign it and send it back to them, nominating your estate as a personal representative, and so that way your benefits from your super come into your estate. If you have a self-managed super fund, you need to review the deed of the self-managed super fund to ensure that benefits that you receive upon your death go back to your will. So please don't forget that, and that's regardless of whether you're separated or not separated.
I just wanted to ask, so is it best to organise and finalise the divorce before I can finish off the Muslim will?
That's a really good question. We've actually drafted the Muslim will in a way that says, I want this will to continue to be valid even after a divorce order is granted by the court. So we've actually designed it to cater to these scenarios. What we pretty much, the philosophy behind Muslim wills is we wanted to capture as many people as possible going through life changes and not updating their will based on those life changes, to make sure that they don't die intestate legally. Okay, so a lot of thought went into the product to make sure that it continues to be valid, whether you're separated, whether you're divorced, whether you have children, don't have children, etc. So for our product specifically, it doesn't matter, because it will continue to be valid because we have that clause in there. But other products potentially don't have it, so I would be checking definitely.
Okay. And can you provide that link for the recorded webinar that you had regarding the separating?
Yes. Fazin will link that. It was a brochure, and we also have a recording to go with it. Sorry, it's that time of night. My brain's lagging.
Oh,
Inshallah,
okay.
Fazil will link it. If you don't get it, sister, email us. Inshallah, we'll send it to you. But I think she's already put it into the chat box.
Okay, Jazakallahu khairan. Thank you.
No, وإياكم. Thank you. Jazakallah khair. All right, I think that's it from the people that had their hand up. Hassan, I answered. Iman, I answered. And I've got Ali. Ali, I think.
Yes, sorry, my wife asked some questions which I
Yep,
have to convey. It's just quick
yep,
one. Firstly,
yes,
you were saying that we should inform the super about our estate. So what is that?
yes.
What do you mean estate? Like Muslim wills or what?
No, no, no. So what you need to do, this is, let me just share my screen. All right. This is a really, really good question. Okay. So what's automatically not included in your will? Okay. So this is what your will, even if you have a will, unless you specifically provide for these things, they actually don't come to be distributed according to your estate. Number one is superannuation. Even if you have a valid will, superannuation legally in Australia is distributed according to whoever is the nominated beneficiary on the superannuation account. Most people don't give it second thought. You would have had a super product when your first employee, you sign up to your employer, they fill out a form, you just fill it out. You're like, yeah, my beneficiary is my husband, my wife. Don't think about it twice. Legally, whoever's named as a beneficiary gets the entire amount of the super. Now, Islamically, the opinion we received from Professor Munir was that compulsory super at a minimum, if not the whole super, should actually come into your estate, come through your will, and be distributed according to your will. Okay? How do you do that? The way you do that is you need to contact your superannuation provider if you have an industry fund. You need to get a form from them that allows you to update your binding death nomination. And on that form, you need to appoint your estate, your executor. Sorry, on that form, you need to appoint your executor as your personal financial representative and the beneficiary. So what you're essentially telling the super provider is, I want my estate to get the benefits when I pass away and for that to be distributed according to the will. Okay. That's a hard copy form in addition to the will that you need to fill out with the super provider, and it needs a wet signature. You need to sign it and send it off to them by post or scan or what have you. And as I said, if you have a self-managed super fund, that's a deed that's separate. Does that make sense?
Yes. Okay. My
Sorry,
second question
sorry,
was,
just while, sorry, I'm just going to pause you there. While we're on this topic of what else is not included, joint held property. If you and your wife own anything jointly, by joint I mean as joint tenants. So for example, you have a house and it says on the title joint tenants. Joint tenants usually applies to houses if you've bought a house and you have it as joint tenants. Or for example, if you have a bank account and you own it jointly, the right of survivorship applies, which means if I pass away and I have my house as a joint tenant with my husband, when I pass away, my entire share goes to my husband, full stop. It doesn't actually come to be distributed according to my will. The same thing for a bank account, for example, okay? So if you actually want a portion or your whole entitlement to come through your estate and be distributed according to your will, you need to change that joint tenancy element. So that's the second thing, jointly held property. The third thing is life insurance with a nominated beneficiary. So life insurance will be whoever the nominated beneficiary is. Assets held on trust, depending on the trust structure, who's the beneficiary. And as I said, jointly held bank accounts. So that's something to note, inshallah. Sorry for cutting you off. Continue, brother.
yeah, my last question is, so I have a disabled child, and
Yes.
so my wife was asking me, is there any way I can mention in the will that let's suppose I want to nominate this person. Let's suppose my elder son, if he turns
Yep.
18, we will give him more money so he can look
Yes.
after him.
Yes.
Something
Yes.
like that.
Yeah.
How
Look,
we
that's
can define that?
yeah. Look, that's a really, really good question. There's an article that my colleague will link in the comments called Providing for Disabled Children. Okay. So you have two options. Number one is while you're alive, you can set up a trust, okay, that has different rules and regulations around how you want your disabled child to be provided for. And you can, for example, start investing some money into that trust, putting some money into it, etc. Okay. That's something you can do during your lifetime, and we really strongly encourage it for where you have situations where there's a disabled child and they have ongoing needs. The other thing you can do is you can allocate so I would be careful about allocating your son the amount to use on the brother, because what if by the time you pass away, like for example, your son's also passed away, or he just isn't available to do what you're asking him to do, okay? So I wouldn't attach the benefit to your son. I would attach the benefit to the person who needs the benefit, okay? So what I would be doing is in the wasiya section, I would be giving an additional amount to the child with a disability, okay? And in the instructions, I would say that I want this extra amount allocated for my child with a disability to be managed, and put your rules and regulations and whatever you want on there, okay? The other thing is in the guardianship section, I would be putting instructions for the guardianship of the child, saying this child has, additional needs or special needs, and I want them to be cared for in this particular way, and put those instructions there too.
Sure. Thank you very much.
No worries, Jazakallah khair. All right, so that's unless I've missed someone, please put your hand up if I've missed someone who wants to ask a question. Otherwise, I'm going to start answering some of the questions that are coming through the chat box. If you do want to ask a verbal question and I've missed you, feel free to turn on your mic and ask it. Okay, so I've got a question here that says, does the Islamic ruling of males inheriting more than females also apply for the contingent distributors? No. So contingent distribution is the distribution if there's nobody eligible Islamically to inherit from you. So what we're saying is Islamically the rules don't apply now because there's literally no one that Islam would have otherwise provided for. Now the interesting thing is if you were in a Muslim country, what would happen is if there's no one Islamically eligible to inherit from you, that money goes into what's known as Bayt al-Mal, or like the public treasury, and it'll be distributed according to whatever the Islamic State needs. Obviously, we live in Australia, that concept doesn't exist. And the opinion we received from the professor who we were consulting on developing this product was in the case that you have no one eligible to inherit from you, you can choose who that goes to. So for example, a neighbor, a friend, but as I said, I usually recommend put a charity for contingent distribution because charities outlive people. And the question says, can I say for my siblings to receive an equal share? No, because your siblings Islamically are allowed to inherit from you. So your siblings, if they're alive, your contingent distribution won't apply. Contingent distribution means that there's nobody eligible to inherit. If you want your your siblings to inherit from you, I would be putting that in the wasiyah section. Okay. There's another question. If I pass away, can I leave 100% to my partner? No, you cannot leave 100% to your partner. Islamically, when you pass away, there are people that are Islamically entitled to inherit from you. And the key difference between Australian law and Islamic law is if I pass away under Australian law and I don't have a will and I have a partner, the partner gets everything. If I have a partner and I have children from a previous relationship, it's half-half, okay? That's the general law under Australian law. Islamic perspective, it's completely different. Parents, spouse, and children inherit from you, okay? So you can't just say, can my partner get everything? Islamically, no. So if you don't want to use our product, then that's an informed decision you need to make. But we've drafted our product for Islamic compliance. So you can't just leave everything to your partner. Sorry, the other thing you can do is, for example, if you have a joint tenancy with your partner, and you want them to continue, for example, owning the property, if you structure it that way for a joint tenancy, that's fine. But you can't just say in the will, I want my partner to get everything. Okay, there's another question that says, can we nominate more than one executor? Yes, you can nominate more than one executor. You can also nominate more than one executor to act together at the same time if you want to do that. So for example, you can have 2 or 3 people acting together at the same time. That's called a joint executorship, and our form allows you to do that. So for example, I would recommend people consider this if you have non-practicing family members, if you have non-Muslim family members, or you have like a family situation that's a bit complex. So for example, you might have a Muslim person, a non-Muslim person, and your accountant, right? So you can have more than one executor and you can have a joint executorship. All right, if my self-managed super fund states my beneficiary is my estate, does that mean you'll form a part of my estate and distribute it as per my will? Without having read your deed, so I can't obviously give legal advice because I haven't seen the document, but generally, if that's what it states, that the beneficiary is the estate, then yes, that is correct. It will go in. And that's exactly what we want all the self-managed super funds to be doing. So that way the benefit to be received from that self-managed super fund goes back into the estate and is distributed according to the will. All right, we have another question. In a case of death, do they sell all the belongings like house, cars, etc. to divide it among predecessors, or is there another way? No, that's exactly what they do, unless there's a particular item that you've already put into the wasiya or bequest. Okay, so for example, if I bequeathed my wedding ring to my daughter, and that's in the wasiya section, then that particular item won't be a part of the putting the assets together, getting whatever's of value and selling off. So yes, they will do that unless there's a particular item that's been named of value that is exempt from that distribution. If both my wife and I die, how can our house, super, and other assets be protected and managed for our two children until they are old enough to manage the money themselves? Look, Islamically, two things. Number one is if your children are alive, but you also have parents that are alive, it's not just your children that inherit from you. So from an Islamic perspective, just remember, if parents are alive, parents are eligible to inherit, okay? If you want to bypass your children, if you want to bypass your parents, you don't want them to inherit from you, then what you need to do is you need to create, for example, say a trust during your lifetime and provide for the trust to hold the assets or have some benefit over the assets, have rights to distribute assets, things like that. So that way, when you pass away, your estate isn't going through you personally, it's going through the trust, okay? From an Islamic perspective, that's not possible if parents are alive. If parents are not alive and all you have is children, then you can, as I said, under 18 children can't usually get their own money anyway. It is held on trust for them. And it is distributed to them after. So you can put instructions into the guardianship section about how you want that done. Can I state that the family home is not to be sold until my daughter marries or if she is happy with the sale? You can state that, but is it legally binding and effective? No, because if the family home needs to be sold to provide for the shares going to the different people who are eligible to inherit, then you can't say don't sell the house because those people need to receive their shares and they can challenge that decision not to sell the house, okay? So what I would be doing is if you want to make it legally watertight to make sure that it's not challengeable, is I would be giving her a conditional life tenancy. What do I mean by conditional is you can put conditions in there. So she has a life tenancy, which means she can continue living in the house, conditional upon getting married, for example, or her not wanting to continue to live there. So relinquishing that right herself, okay? That's something you set up during your lifetime. It has nothing to do with the will, and see a solicitor to do that, but that's the way to do it to make sure it's absolutely watertight. Is it possible to provide a certain type of investment, for example, properties, shares, etc., to my only child under the Islamic law? Again, if the only person that's alive is your only child, so you don't have parents, you don't have a spouse, then yes, you can do that. However, if your parents or your spouse are alive, then no, it can't just go to your child. You can give them an extra amount through the wasiya section up to 33%, 33.3%. And you can say, for example, in the description for wasiya, I want this property or this share portfolio to be what the child receives as a part of this distribution in wasiya. We have an article on Muslimwills that tells you how to put those instructions in if you want a particular asset type to go to a particular beneficiary under the wasiya. Life tenancy, what's the governing body for that? or is it a solicitor life tenancy? Life tenancy is a document you need to actually draft during your lifetime. So you would see a solicitor and ask them to put together a life tenancy, and you put the conditions you want for the life tenancy. So for example, as I said, I want for this particular person with these conditions, and that's something you see through a solicitor. If you want a list of solicitors that can do this work for you, you can email us. We have legal referral partners. They are independent law firms that do that have tendered for us. We know that they understand the Islamic law and they understand the legal processes. They're completely independent of us, so you need to double check their charges and see what the arrangement is. But this is a document that you should do while you're alive. Okay. I'm just checking if there's anything else. If you do call the Muslimwill's hotline, you won't be speaking to a solicitor. You'll be speaking to our admin team. Also, Muslimwills is a project of Awqaf Australia. Awqaf Australia is not a legal service. So we don't give you legal advice, guide you in the right direction to get further legal advice, a qualified solicitor. Okay, I think we've reached the end of the questions. The last thing I just want to quickly mention is if you are a convert or a revert to Islam, there is a whole set of Islamic regulations that apply to you. So when you're going through our questionnaire, please make sure that you're filling it out properly and you're actually ticking if you are a convert to Islam, because Islamically there's different rules that apply depending on whether or not you have family members alive that are Muslim or you don't have any Muslim family members. So Muslim converts, it's a completely different story. For time purposes, I don't have time to go into that, but please make sure that you look into that if you are a Muslim or you have non-Muslim family members. The last thing I want to touch on, inshallah, and we'll wrap it up, is I spoke about how the distribution of your estate is your last act of ibadah on earth, and Islamically it's really important to make sure that we have our affairs in order. So when we do pass away, that Allah subhanahu wa ta'ala, we can safely say, look, I've done my best and the rest was up to my family. The other thing you can do, the hadith says that when somebody passes away, all their deeds stop except through 3 avenues, essentially. One is a righteous child that makes dua for you, beneficial knowledge that gives, or sadaqah jariyah. Sadaqah jariyah is ongoing charity. What ongoing charity means, it's charity that doesn't stop after the donation is given. And one example of sadaqah jariyah is waqf. Waqf means it's a donation. When you donate something, the amount of the donation or the capital is preserved, it's invested, and the returns from that investment are what's used to donate to charitable causes. And Awqaf Australia has launched Australia's first cash waqf platform, which allows you to actually give donations into a cash waqf system and receive those benefits, inshallah, on an ongoing basis. And that's something you can do during your lifetime. You can give to waqf during your lifetime. You can establish a personal waqf during your lifetime, and have that as a benefit, and you have a directed avenue for all your sadaqah, not zakat, sadaqah. And then what you can actually do, and this is the most beautiful thing, is that same waqf structure that you set up during your lifetime, you can actually name that structure in your will through the sadaqah jariyah component in the wasiyah section. So up to 33% of your will can actually go to sadaqah jariyah if that's the amount you want to declare. Okay, so it's the only thing where you can actually set it up during your lifetime that will continue after your death through your estate. And through the Muslimwills platform, we've actually allowed you to do that, pre-populated that through the wasiyah section. And if you do want to set up a waqf during your lifetime, if you want a named waqf, please contact us at Awqaf Australia. My colleague will be putting our contact details in the chat box, inshallah. And as I said, think about it as an act of charity that starts with you during your life. You continue the legacy after your death, and it also allows your loved ones and people close to you to continuously give to the causes that you care about through your waqf after you've deceased. So that's that, inshallah. I think I will end it there. Jazakumullah khairan for all your input. Thank you for those who asked questions and put the questions through. And if anyone has any questions, we're always happy to help anyone who needs anything, please either call our hotline or email us, inshallah, and we'll be there to help you. Jazakumullah khair. Thank you so much for your time, and assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.